Welcome to this explainer. Okay, picture this. Someone owes you money, but the thought of hiring an expensive lawyer just makes your stomach drop. Well, you're in exactly the right place. Today, we're totally flipping the script. We are going to empower you to bypass those crazy legal fees and handle a small claims case in Oklahoma completely on your own. It's way easier than you think.
Right? Are you owed money, or maybe some property, but you're thinking, a lawyer's going to cost way more than I'd even win back. Look, you are definitely not alone in feeling that way. But here is an incredibly empowering thought to kick us off. Oklahoma's People's Court is actually designed from the ground up to be super accessible. It's streamlined for everyday citizens just seeking straightforward justice. You absolutely do not need a fancy legal degree to get your money back. You just need to know the procedural roadmap. And that is exactly what we're giving you today.
Speaking of that roadmap, here is exactly how we're going to break it down. First, the basics and eligibility. Second, preparing and filing. Third, serving the defendant. Fourth, preparing for court. Fifth, the hearing and outcomes. And finally, number 6, actually collecting your judgment.
Let's dive right in. Section 1, the basics and eligibility.
So, in Oklahoma, the absolute hard cap for small claims is $10,000. You can sue for anything up to that exact amount, which honestly makes this the perfect venue for those more modest, everyday disputes. But keep in mind, this limit is strict. It's a hard ceiling. You can't just voluntarily shrink a much larger claim to fit into small claims court unless you are willing to permanently waive your right to the rest of that money.
Now, small claims court is built for absolute efficiency. It's basically the fast-pass lane of the legal system. If you filed on the regular civil docket, man, your case could easily drag on for well over a year. But here, by law, your case is actually required to be heard no more than 60 days after you file. Talk about a speedy resolution.
So, what exactly belongs in this court? Well, you can confidently file for things like breaches of contract. Think of a contractor who took your deposit and just walked off the job. Or you can file for unpaid invoices, wrongfully withheld security deposits, or minor property damage. But, and this is a big but, complex defamation claims, stuff like libel and slander, those are strictly excluded. For those, you'd have to head over to the regular district court.
Okay, tick-tock, because time is of the essence. You only have a specific window of time to file your lawsuit before your claim legally expires. This is known as the statute of limitations. If your dispute involves a written contract, you have 5 years from the date it was breached. For an oral contract or an open account, that drops to 3 years. And if you're dealing with property damage or personal injury, you only have 2 years to get your case filed. So whatever you do, do not let that clock run out on you.
All right, moving right along. Section 2, preparing and filing.
The absolute best part about this process is that you don't need to draft massive, complex legal pleadings. Seriously, you literally just fill out a standardized form called a small claims affidavit. You grab it at the clerk's office, and it simply asks the basics. Who are you suing? What's their address? Exactly how much money is owed? And a brief reason why. It is incredibly straightforward.
Now, of course, accessing the court isn't totally free, so you should anticipate a few out-of-pocket costs right at the start. Oklahoma operates on a tiered sliding scale based on the exact dollar amount you're suing for. Suing for $5,000 or less, your total base fees and statutory assessments will usually sit right around $58. But if your claim lands between $5,000 and that $10,000 maximum, you should expect to pay anywhere from $212 to $219, just depending on your specific county's law library fees. Oh, and if you genuinely cannot afford these filing fees, don't worry. You can file what's called a pauper's affidavit to request a full fee waiver based on low income.
You'll notice that these exact filing fees have to be paid right when you submit your paperwork. It's literally a pay-to-play situation. No fees paid means no court date gets scheduled. It's really that simple.
So, to quickly summarize this filing phase, first, make absolutely sure you're filing in the proper venue. In Oklahoma, that's usually the county where the defendant actually lives, or where the contract was broken. Second, fill out that small claims affidavit we just talked about. And third, pay your fees to the clerk. Also, some amazing news for the tech-savvy folks out there, Oklahoma actually operates a highly digitized judicial filing system. That means you can electronically file your case via the oscn.net portal across all 77 counties.
Which brings us to Section 3, serving the defendant.
Getting the paperwork filed is great, but now you actually have to let the other person know they're being sued. In Oklahoma, you've got 3 primary options for serving the defendant. Option 1 is having the court clerk send the summons via certified mail with a return receipt requested. Honestly, this is your cheapest route.
Option 2 is paying a statutory $50 fee to have a sheriff's deputy deliver it in person. And Option 3, you can hire a licensed private process server. They'll charge their own commercial rates, but they specialize in tracking people down and physically handing them the papers.
Now, timing is absolutely everything here. The defendant must legally receive this notice at least 7 days before your scheduled hearing date. And listen closely to this part, because Oklahoma courts are super strict about due process. If you try that cheaper certified mail route and the envelope comes back to the clerk marked as refused or unclaimed, you can't just cross your fingers and assume they know about the court date. Nope. You have to immediately arrange for personal service, like sending the sheriff or that process server. If you don't, your case legally cannot proceed, and your hearing is going to get delayed.
Okay, so they've been served. Section 4, preparing for court.
Now, even though small claims court is way more relaxed and informal, the judge is still bound by the rules of evidence. You can't just waltz in there, tell a really compelling story, and expect to win. You have to bring physical proof. We're talking signed leases, printed invoices, crisp photos of any damage, and yes, even printed out text messages or emails. And if you have witnesses who saw what happened, they need to physically be there in the courtroom with you.
And hey, write down this vital number because it will save you a massive headache on your court date. The magic number is 3. You need to walk into that courthouse with 3 copies of every single piece of evidence you have. 1 copy is for the judge to review, 1 you have to hand over to the defendant, and 1 stays with you so you can reference it while you're presenting your case.
All right, the big day is here. Section 5, the hearing and outcomes.
So what actually happens? Well, you'll be participating in what the legal world calls a bench trial. Basically, it's just a highly accessible, streamlined hearing where there is no jury, none of that dramatic TV courtroom stuff. Instead, a district judge or a special judge just sits down, listens to the evidence from both sides, asks some clarifying questions, and really tries to keep things simple for everyday folks who don't have lawyers. After both of you present your sides, the judge issues a binding ruling, and they often do it right there on the spot.
Let's say you win. Section 6, collecting your judgment.
So you won the case, which is awesome. But right after, there's a 30-day window where the defendant is allowed to file an appeal. Once that 30-day window slams shut, if they are still refusing to open their wallet and pay up, you get to use some pretty powerful legal tools. You can apply for a wage garnishment, which literally takes up to 25% of their disposable income straight out of their paycheck. Or you can request a bank levy to seize funds directly from their checking or savings accounts. You can even place a lien on their real estate, and that lien remains valid for a full 5 years. And get this, it can even be renewed.
And definitely don't panic if the defendant drags their feet and tries to stall, because under Oklahoma law, your unpaid judgment actually grows over time. That's right. It automatically accrues post-judgment interest at the U.S. Treasury bill rate plus an extra 2%. So literally every single day they delay paying you, they legally owe you a little bit more money.
Okay, to wrap this all up, please keep in mind, this explainer provides educational information only, not formal legal advice. If you ever feel totally out of your depth, definitely consult a licensed civil attorney in Oklahoma. But the biggest takeaway here, the system is literally built for you to use. Do not let the fear of a courtroom cost you the money you are rightfully owed. So, what steps will you take today to reclaim your money?